Good afternoon, everyone. I'm pleased to welcome you to our webinar, Supporting the Health of Survivors of Family Violence in Family Law Proceedings. As you'll note on the first slide, all of you are muted during the webinar, so don't check your sound system for problems. It's easier with 700 odd people online to keep all of us muted without video. If you're experiencing any issues, please type questions into the chat box and we'll try to help you. If you have questions for the webinar speakers, please type them into the Q&A box, and we will be spending half an hour. At the end of the session to deal with those questions. There will be an evaluation link in the chat box at the end of the webinar, so please fill in the form to give us feedback and guide our future webinars. Now, once you've completed the evaluation form, you'll be directed to a website where you'll be prompted to enter your name and email address, and you can get a certificate of attendance emailed to you at that point. Our presentation slides are posted on our website, and there's a link in the chat box. The webinar will be recorded and posted on our website within the next few days to assist those of you who have colleagues who may want to follow along this webinar. I want to reflect for a moment on acknowledging the lands that we're on. All of you are in different places on Turtle Island from coast to coast to coast. Please think about the traditional lands you're currently situated on and join us in acknowledging and thanking the generations of Indigenous people who've cared for these lands and in celebrating the continued strength of and spirit of Indigenous peoples. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular to bring justice for murdered and missing Indigenous women and girls across the country should inform our discussion in this webinar and beyond. I want to introduce our speakers, and I also want to start by thanking the Public Health Agency of Canada, who provided a grant that's going to help us develop communities of practice from coast to coast to coast across the country, and we appreciate their support. Today, for this webinar, we have two outstanding speakers. I'll introduce both of them. They'll each start by talking about some of the problems that they see, both from a legal and a clinical perspective, and then they'll be back to talk about some of their ideas about promising practices and hope that may be on the horizon. Pam Cross is a feminist lawyer, well known and respected for her work on violence against women in the law. She's well recognized across the country for her work, and as most of you know, she's a legal director of Luke's Place in Durham region. Linda Baker is a psychologist. She's a professor, adjunct professor at Western University and the learning director for the Center for Research and Education on Violence Against Women and Children. And she comes to this work with a quarter-century involvement in children's mental health, also closely tied into forensic work in this area. So with that, I will turn it over to Pam Cross. Welcome, Pam.
Thank you, Peter. And welcome to all of you. Thank you for joining us. This is a busy time of year. It's been a busy year thanks to the pandemic, and it's the end of the day. So we're really appreciative that you have found some time to join us from right across the country. I have to say that when Peter asked me to do this and said that I could spend roughly an equal amount of time talking about challenges with the family court system as I could about promising practices, I was a bit dubious because from what I see in the work that I do in Ontario with survivors of family violence, there's a lot more challenges than there are hopeful expectations or promising practices. So for the next roughly 15 minutes, I am going to talk about challenges. I have distilled down a much longer list to what I have time to talk about with you this afternoon. But I'm also including links to various papers I've written that explore the challenges that I'm talking about in greater detail. as well as dig into some of the other challenges that I'm not able to cover this afternoon. And there are reasons to be hopeful. I'll come back to that a little bit later after you hear from Linda. But it is certainly the case that when a woman is considering leaving an abusive relationship, especially if she has young children, or in the period of time shortly after she's left, which we all know is the time when she's at the greatest risk of increased abuse up to and including lethal violence, she's presented with some very unattractive options. If there are kids, she has to sort out custody and access, or what we now call parenting arrangements for those children. But how's she to do that when she's dealing with an abusive partner or former partner who's going to use that very legal system against her in every way that he can? When we think about accessing court, we know, as I said, that most women are going to have to engage with family law. That can be a very unsafe process. It's certainly almost always difficult, if not impossible, for her to negotiate with her former partner. So while two people who are separating because they no longer love one another or because one of them has become involved in another relationship may have challenges sorting out their issues because of hurt feelings, they're at least not dealing with issues of safety. And often both of those parents, regardless of how they feel about each other, are able to put the best interests of the children first, and at least to some extent, set aside their personal feelings. That's just not the case for families where there's been a history of intimate partner abuse. Abusers don't come into the process with clean hands. They don't come to the process necessarily with the best interest of the children at the front of their mind. They're focused on how they can continue to maintain power and control over their partner. The court system, or the legal system, I think I should say, rather than the court system, unfortunately creates many opportunities for that abuser to continue to intimidate and manipulate the partner and the situation to his advantage. If we think about mediation for a minute, which is very often right across this country presented to women as the preferred option, the option that she's going to be prepared to engage in if she really cares about her kids. I'm putting quotation marks around that and saying that somewhat sarcastically, may work in some cases where there's a history of family violence, but in many, it's simply not appropriate. It's private as opposed to public, like the court system is public. And it does provide unique opportunities for abusers to bully and intimidate their former partner. And yet that's often the first option that's presented to a woman when she's meeting with a lawyer or even a counselor to talk about how she's going to resolve her family law issues. And many women understand that that is then what's required of them as opposed to being an option. Having said that mediation may not be the best option, I want to be clear that going to court also presents a number of barriers. Fear. Many women are extremely fearful at the point of separation, and understandably. There's a lot of unknowns ahead of them, and they just don't know quite how things are going to develop. They have fear about the abuser. They're fearful about what court outcomes might be. They may well be fearful about an intervention by child protection authorities. Not all, but many women, after experiencing and being subjected to abuse for many years, are dealing with trauma, which means they may have difficulty taking in and retaining information that they're receiving from their lawyer. It may be difficult for them to make decisions because they're not used to doing that. They may have trouble following through, engaging constructively with the court process. All of that can sabotage them in that process. Few people have much knowledge about the legal system until they have to be involved with it. Many women believe the abuser's promises, and yet the cycle continues even after separation. We know that more than 50% of people involved in family court in Canada right now don't have lawyers. And then for some women, there's a lack of trust in the court system because of their previous experiences, whether that's been in criminal court, dealing with family law or other legal issues in other countries, and so on. Well, the focus of this webinar today is not specifically on the pandemic. I do want to make just a few quick comments about accessing family court during the pandemic, because it's become even more challenging. In the first few months of this year, family courts were only hearing the most urgent of matters and were not opening new files. Court services were moved from in-person to virtual, and at least in Ontario, that included duty counsel, which made it very tough for someone without a lawyer to get any legal advice or support. Everything was being dealt with remotely, which created serious difficulties for survivors in rural and remote parts of the country because of limited internet access. It also created difficulties for those who don't speak English and French, or who don't have a lot of computer skills. There are security issues too, in terms of the abusive partner hacking into the woman's accounts to see her court documents or communications with her lawyer, or harassing her during an appearance through repeated text messages or phone calls. If, unbeknownst to her, he has a GPS on her computer, he can find out where she is during the court appearance and harass her by, for example, having fake deliveries come to her door, or by sending family members to that location to harass her. Women stuck at home with an abuser because of the pandemic have difficulty meeting with a lawyer or accessing other court-related services because they lack the privacy for those conversations. It's pretty tough to try to talk to a lawyer about wanting to leave your partner, or a support worker about a safety plan, if the abuser can hear every word of that conversation, or can access the email account or internet searches. Even now, as some courthouses are beginning to offer some in-person appearances and services, challenges remain. Often the biggest difficulty is getting accurate and current information about how the court is operating now, because the operation of courts is changing so quickly. So in Ontario, to help out with that, Luke's Place, at the link that we've provided here, posts frequent updates about the status of Ontario courts on its website. Once a woman gets herself to court, she then, of course, has to present a case that reflects the history of family violence, and that can be very challenging, pandemic or no pandemic. Once again, I have to mention the lack of legal representation. In family court cases generally, more than 50% of litigants across the country do not have a lawyer. In some locations, that number is much higher, and you'll be familiar what the rate is where you're living and working. Of course, this is a problem for anyone, but it's a much more serious issue for cases that involve family violence. If the survivor is unrepresented, she may not be aware of her legal rights. She may not even know what outcomes she should be looking for. Does she know that there's such a thing as a restraining order or a protection order? Does she know that she might be able to get an order that gives her exclusive possession of the family home, and so on? She may not be aware of different legal processes or understand which of them are appropriate for her. Especially if her partner is representing himself, and this is common, I'll talk a bit more about that in just a minute, there will be serious safety issues for her, emotional as well as physical, because there will be no buffer provided by lawyers. The two of them will be dealing with their case directly with one another. And in fact, she and her partner may have to serve court documents on one another directly, certainly an unsafe situation. Legal bullying is all too common in cases involving family violence. It's a tactic that many abusers engage in during the court process because it lets them draw the proceedings out. It lets them maintain their power and control for even longer. They can hope that they will wear their partner down emotionally or run her through all of her financial resources, and that increases the likelihood that they'll get the outcome they want. Of course, there's a lot of different ways that legal bullying can play itself out. I'm just going to mention a few of the most common. We see many women whose partners could have a lawyer, either because they would qualify for legal aid assistance or because they could afford the lawyer out of their own pocket, but they choose to represent themselves strictly for the purpose of intimidating and harassing their partner. Many abusers seek repeated delays. They fail to file their documents on time, or they file them intentionally incomplete or incorrect, especially financial documents, all of which requires the woman to go back to court again and again for adjournments and to live for a long period of time in this state of uncertainty. Repeatedly changing lawyers is another common legal bullying tactic. Especially in smaller communities, abusers may make an appointment with each family lawyer in that community, which means that even if he doesn't hire any of them, they're now all professionally prohibited from representing the woman. Abusers enjoy going to court when they're representing themselves. They don't have to pay a lawyer for the lawyer's time or use up hours on the legal aid certificate. So they bring frivolous motions about issues that have already been decided or issues that are just ridiculous. And of course, often they refuse to follow court orders. In addition to that, survivors have difficult experiences in family court. They're very likely to encounter at least some professionals who have limited or no knowledge about family violence, and in some cases, outdated attitudes that blame the victim or don't see intimate partner abuse as relevant to what's best for the children. Because of this, and an attitude common among family court professionals that children do best when both parents are equally involved in their care, survivors of family violence often emerge from their court case with an order for shared parenting, joint custody, or the equivalent. This forces them into a long-term arrangement in which they must consult with their former partner, who, as I mentioned a few minutes ago, may well not have the best interests of the children in mind. And yet every time the mother wants to make a decision about the kids, she has to consult with her former partner. Even if the order is not for shared parenting, but requires frequent and extensive access, the woman is enforced to engage with her abuser repeatedly on an ongoing basis, and he can use those encounters as a chance to bully, harass, intimidate, or even physically assault her. Obviously, neither of these situations is good for anyone other than the abuser, who gets what he wants: ongoing control over his former partner. Finally, before I hand things over to Linda, I want to just take a minute to talk about some of the risks for a woman when she discloses a history of family violence in her case. Obviously, it's very important for the court to be aware of this history of abuse, and yet raising it can have adverse consequences for the woman. It can increase the risk that the abuser will engage in elevated levels of abuse towards her or possibly the kids, and that can place women and their children at serious risk of being killed. If the woman hasn't taken the steps that the professional, whether that's her lawyer, a mediator, an assessor, or even the judge, thinks are the appropriate steps. So for instance, if she's never called the police, if she didn't leave the relationship after the first episode of abuse, this can mean that that professional doesn't take her evidence seriously or doesn't attach much weight to her story of abuse. It's also very difficult to find so-called reliable evidence of family violence because often there are no witnesses and the woman hasn't told anyone about what she's being subjected to. It's not uncommon for the abuser to respond to any allegations of abuse by first denying them, second, alleging that it's the mother who's the abusive person, and then perhaps making a claim of parental alienation against the mother. Once this claim is made, the attention of the court will be diverted to that, with the woman's initial statement about abuse becoming forgotten. So as I say, this is a brief look, a brief overview of the challenges with the family court and family law system for women who are fleeing abuse. Unfortunately, there's no haven in family law for women in this situation, especially for those who have children. There is, however, some hope, and I'm going to talk about that after you hear from Linda. So Linda, over to you.
Thank you, Pam. I'm going to switch it up just a little bit now and look at in a little more detail some of the health impacts of domestic violence and how they may affect presentation in court. Pam spoke about the barriers, and in talking about the barriers, some of the barriers are actually the impacts that a survivor may be experiencing due to the abuse. And this slide just captures that it's a range of functioning that's affected, and that those effects, they can range from disrupting daily routines, they affect parenting, work life, absentee, maybe poor work performance due to what's going on to that woman, economic stability, and of course, long-term health. And the focus I want to take today is on one of the impacts that was identified as a barrier by Pam, and that's trauma. Before we do that, I want to just provide a little bit of context. Kimberly Crenshaw's intersectionality framework tells us that we cannot understand a survivor's experience of violence simply by considering one or even a couple of dimensions of an individual's identity. That is because experience is shaped by the combination and intermingling of our multiple identities: gender, race, ability, socioeconomic status, culture, age, and by the social structures and institutions that privilege some identities and disadvantage others. For instance, the experience of IPV and appearing in court of an Indigenous woman living with a disability will be shaped by the historical and ongoing colonization and racism that leave her distrusting and fearing authorities, and the reality that she is dependent on the very person who abuses her as a caregiver. Actors in a given system, such as the court system, are also influenced by systemic power relations that maintain and reproduce particular discriminations and exclusion, some of which are captured in the graphic on this slide. And this impacts how those actors view the people they serve. I want us to keep this in mind as we move on and look more closely at trauma. Perhaps the most simple way of describing trauma is that it directly or indirectly involves an exposure to an actual or threatened death, serious injury, or sexual violence that overwhelms one's coping. And we know that the same event may be experienced as traumatic by one person and not another, dependent on the trauma history, the accessibility or lack of immediate intervention, and the resiliency of the person at that time. We also know that a trauma can be acute, like a single episode of domestic violence. It can be chronic, prolonged and repeated exposure and experiencing of domestic violence. And it can be complex. And we think of how we differentiate chronic from complex trauma in the sense that complex trauma involves varied and repeated invasive trauma by someone close to the victim that often begins in childhood or adolescence. So for some individuals who are being abused in an adult relationship, this is coming after they have experienced complex trauma in childhood. Any trauma, whether it's acute, chronic, or complex, can potentially have physiological effects. And we know that chronic trauma is more likely to have such effects, as is complex trauma. And in the blue balloon, we can see what some of those effects are. So we see impairments in memory, learning, and mood modulation, as well as heightened sensitivity to stressors, chronic activation of the physiological stress responses So we have a surge of hormone release that prepares the individual for fight, flight, or freeze. And that chronic activation of the physiological stress response is accompanied by increased frequency or intensity of experienced fear and anxiety. There's two areas I'd like us to look at a little more closely. The first is post-traumatic stress disorder and traumatic stress. And I include traumatic stress because individuals can be affected by traumatic stress, and to the extent that it significantly disrupts their lives, and yet not meet the criteria for a diagnosis of post-traumatic stress disorder. And all of us know that one doesn't need a diagnosis to legitimize the experience of traumatic stress. The hallmarks when we talk about post-traumatic stress or traumatic stress symptoms are avoidance of reminders of the traumatic event, as well as emotional numbing or detachment. Withdrawal from engagement with life generally is often what we see. Hyperarousal, or sometimes we refer to it as hypervigilance, is that pattern of increased arousal that causes traumatized people to become easily distressed by minor irritations. Their perceptions confuse the present and traumatic past at times, such that they react to what we may see as many ordinary frustrations as if they were traumatic events. Intrusive, destabilizing experiences, such as flashbacks, and intense emotional responses to reminders of the traumatic events, sometimes described as repeated living of traumatic memories. These reminders are commonly known as triggers. And for some survivors, being in a courtroom, physically close to the person who has abused you, particularly when intimate partner violence is being discussed, constitutes a potent trigger. Instead of following the discourse and responding as expected or instructed, the survivor may have flashbacks or feel overwhelmed by emotion. This state increases the likelihood that she may lose track of what is happening in the courtroom and skip, forget, or be unable to say what she wanted to say. We also know that traumatic memories are encoded differently than regular memories. And our first real understanding of this, I think, dates back to Judith Herman. And she flagged what now some of our more advanced technologies have supported, the unusual qualities of traumatic memories. These memories are often such that they lack verbal narrative detail and context. They're encoded in the forms of sensations or images. So it's not that they're less vivid. In fact, they can be very vivid, but they tend to be more like fragments, pieces of a puzzle. Another area when it comes to trauma that's recently received attention is traumatic brain injury. Some of the researchers in this area, such as Helene Jackson, have described this as the hidden consequence for intimate partner violence survivors. And when we think traumatic brain injury, for the general public, their first thought is going to be of professional sports players, not people who are experiencing domestic violence. Traumatic brain injury, what we're finding from some of the most recent research, is actually quite common. It occurs because of a blunt force trauma to the head. So being hit by an object, having your head smashed against something, or being violently shaped. It can also occur from reduced oxygen to the brain through strangulation. Recent research by Eve Valera and Jackie Campbell indicate that the greater the number and the more recent the traumatic brain injuries, the more poorly women tended to perform on measures of memory and learning, and the higher the levels of traumatic stress symptoms. And it's very challenging to tease out the impacts of traumatic brain injury from traumatic stress. They compound one another. These researchers also let us know from their research that even mild traumatic brain injury can result in significant impacts on memory and behavior, and that can lead to confusion, again, poor recall, and difficulty integrating aspects of experience. We held a forum at the Learning Network just recently in 2019, and some of the leaders within Canada and the United States came together. And part of the findings from their work was that most often, even when a survivor goes to the hospital, that there may not be a screening for traumatic brain injury, that somehow it's seen as just the context of domestic violence rather than a potential traumatic injury. And like we know and have learned from all of the publicity around professional athletes, which is a good thing, by the way, we know also that survivors experiencing traumatic violence, they would benefit most from a quiet, non-bright environment that's non-stressful, from concise, repeated communications and memory aids. And I want you just to think about that list that I just shared. And it's certainly not the environment we associate with courthouses or courtrooms. When we think about those impacts of trauma and traumatic brain injury, it's not surprising that the things we've been discussing can impact how a survivor presents in court or in appointments for court-ordered evaluations. So the presentation, she may appear distant or distracted, inattentive. If there's flashbacks or intrusive imagery going on, then certainly that distracts one from attending. Displaying poor recall. We talked about the memory problems and challenges that can come with traumatic stress and also with traumatic brain injury. Information may be shared in a disjointed or incoherent way, and a survivor may appear angry or hostile, especially towards a partner. And we may see this if something reminds them of traumatic, but also just the practicalities, the fact that one is there in terms of trying to defend oneself after what they've experienced. So survivors may appear very reactive or display intense mood fluctuations that may be observed during a custody and access evaluation. It may happen in court, or we may find that a survivor doesn't show up. Part of that avoidance is not even to go or not to return after recess. So what does this mean? Why is it important to talk about this? When intimate partner violence is a factor and violence and trauma are not understood, then the emphasis shifts from what happened to her and the children and how is it impacting this family to what's wrong with her and how is she impacting this family. And when that shift occurs and plays out in terms of custody and access matters and other family court matters, then the court experience for a survivor is likely to involve feeling not understood by the court, feeling that her experiences were dismissed and the significance of the harms that she experienced had been trivialized, and to feel further traumatic stress, upset, frustration, hopelessness, lack of control. The very thing that can occur when we talk about re-traumatization within courts. And if joint custody or shared parenting or frequent access is the outcome, as Pam described, then she may feel the court not only didn't understand her and dismissed her concerns, but that court is actually putting her children at risk. Pam, some hopeful parts.
Thank you, Linda. I am going to try to be a little more cheerful now. And I'm going to start, as a lawyer should, by talking about changes in the laws that have the potential to improve the situation for women leaving abusive relationships. I'm sure many of you are aware that the Divorce Act, which is a federal law, in fact, it's really the only federal family law in Canada, has undergone a significant change over the past year. Those changes come into effect on March the 1st of 2021. So just before I talk about the changes and why they're a moment of hope or a hope on the horizon for the kinds of families that we're talking about this afternoon, let me just, for those of you who aren't immersed in family law, just explain that the Divorce Act, a federal law, applies to people wherever they live in Canada, but those people have to be married and they have to be applying to the court for a divorce. There are provincial laws and territorial laws that deal with virtually all of the same issues except for divorce, but they're different from one jurisdiction in the country to another. By way of example, I live and work in Ontario. In Ontario, we have two pieces of legislation that cover between them the issues that are covered by the Divorce Act. We have the Family Law Act and we have the Children's Law Reform Act. Every province is slightly different. However, the Divorce Act applies across the country. These changes that are coming into effect in about 3.5 months' time are the first significant changes to the Divorce Act in nearly 30 years. And while the changes touch on many, many things, including interjurisdictional support orders and all manner of those issues, the really, really substantive changes to the Divorce Act are those that relate to how decisions get made by courts about post-separation arrangements for children. Of particular relevance to what we're talking about today, the revisions to the Divorce Act include a detailed and expansive definition of family violence. That's not been in the Divorce Act in the past. This new definition appears directly in the best interests of the child test. Again, for those of you who don't work primarily in this area, the best interest of the child test is how decisions about parenting arrangements are made wherever you are in this country. If a court is dealing with a custody and access or a parenting issue, their decision has to be made using this mysterious test, which is slightly different in different parts of the country, but that's what it's called, best interests of the child test. So now family violence is included in that list as a factor that judges must consider. The definition of family violence in the new Divorce Act uses the language of coercive and controlling behavior, which is something that I think women have the greatest difficulty getting family courts to understand. So it's fantastic that it's now part of the definition. The definition also includes as examples of abuse, intimate partner abuse, sexual, psychological, and financial abuse, and threats or actual harm to animals. Again, very serious and common elements for many women in the abuse they've been subjected to, but very difficult to have taken seriously by the courts. And finally, and again, this is a summary of a much longer list, the conduct need not constitute a criminal offense for it to be considered as family violence in a family law proceeding. And I can't stress enough how important and positive that change is. The revised act also includes a comprehensive list of factors to be considered by the court when it's determining whether or not family violence should be considered, a detailed list of criteria to support the best interests of the child test, And although the jury's kind of out on whether this is a good thing or a bad thing, there's no more custody and access. Those terms have been replaced with the terms parenting time and decision-making responsibility. It certainly is the opinion of many that the language of custody and access created a win-lose dynamic in family court proceedings. And there's a hope that these new terms will be able to let people sort out parenting arrangements for their kids without feeling like somebody's winning and somebody's losing. Too early to know yet because the legislation hasn't even come into effect, but time will tell. If you're interested in learning more about the details of the new Divorce Act, we've given you a link to a webinar that Luke's Place has done on just that, going through all of the changes in some great detail. So that's the federal law. Still on the hopeful front, some provincial family laws already use similar language. Others, like Ontario, are in the process of amending their laws to align with the new Divorce Act. Ontario recently passed a bill that will change the Children's Law Reform Act so that it is almost exactly the same as the Divorce Act. And this is really important because, as I said earlier, the Divorce Act only applies to people who are married. Lots of the people we work with at Luke's Place and lots of the people many of you work with are not married to the other parent of their children. And so all those wonderful changes in the Divorce Act have no impact on them unless the provincial laws where they live also change and include these detailed definitions of family violence and so on. Another positive piece of work that's happening is from the federal government. The changes to the Divorce Act have propelled a series of educational and other resources that the Department of Justice is developing. In particular, it's leading a multi-sectoral project to assist family law legal advisors, which is the fancy new language for lawyers, to support clients who've been subjected to family violence. The project is developing a tool. It has a working title that's a real mouthful. It's called Help Toolkit for Family Law Legal Advisors, Identifying and Responding to Family Violence. And it will provide practical suggestions on how to identify and respond to family violence in a way that's safe for the client. Expected completion date for this tool is next summer. The tool grew in part out of research that I was involved with through Luke's Place in 2018, in which we looked at screening tools, different kinds of screening tools, how effective they were, and then through that research established the importance of encouraging all family law lawyers to screen for family violence at the beginning of each new case. That research we've given you a link to. So in effect, while this tool isn't called a screening tool, that's very much what it's going to do. It's going to equip lawyers, even if they don't have a lot of experience working with clients who've been subjected to domestic violence, with the information, the skills, and hopefully the confidence to be able to ask the right kinds of questions, to draw out information about a history of family violence. Because many, many survivors don't disclose. They're embarrassed, they're afraid, and so they just don't tell. The tool will give lawyers a suggested approach to asking about family violence, and then it also includes resources to increase the lawyer's knowledge and awareness about many aspects of family violence. Also upcoming in 2021, the Department of Justice will be releasing an online self-directed family violence training for family law practitioners, which is going to be really helpful because a lot of lawyers, most lawyers, want to do the right thing, but they need to have the knowledge to do the right thing in cases that involve family violence. So I am feeling quite hopeful that both of these resources will increase the skills, knowledge, and comfort of family law advisors in managing cases that involve family violence. And that will then lead to better outcomes for survivors and their children. There's one issue that persists, and it's one that I get asked more questions about than anything else when I speak at conferences, and that is, what about the judges? How can judges become better educated about family violence? I have had a lot of despair about this for the last 20 years or so. I feel a little bit of hope because of Bill C-3. Bill C3 was passed by the House of Commons in late November, and it mandates sexual assault education for newly appointed federal judges, so it's a fairly narrow bill. But I'm taking that as a possible launching pad to now convince the federal government that there should be a similar approach to family violence education for family law judges. And when judges are better informed, they're going to make better decisions. There's just no doubt about that. But let's talk about what happens at the community level, because I think there's a lot to feel hopeful about there. And I think we have to remember that positive changes that have happened have come because those of us working at the grassroots have worked to make them happen. They don't just usually spring from the mind of a politician or a senior bureaucrat. They come from the grassroots up. And while these are resources that are in Ontario, because that's where I work, they can serve as a model or inspiration to folks in other parts of the country who may be interested in similar ideas. Empowering survivors is an important part of improving their health during and after their family court experience. Family Court and Beyond does just that. This is a resource that is also a website written specifically to support women throughout their family court case. It includes basic legal information, as well as tips, fact and worksheets to assist a woman track her own case and record information about her safety plan, evidence, communication with her former partner, and so on. So of course it has an Ontario focus, but a lot of the content in that book is useful to people anywhere in the country. For community workers in Ontario who want to understand more about family violence and family law, CLEO, which is the Community Legal Education Ontario organization, hosts a series of webinars, each of which explores a different aspect of a family law case examined through the lens of family violence. And just one final plug for work that we're doing at Luke's Place, again, specifically useful in Ontario, but we have developed an online self-directed course for lawyers who want to know more about how to represent survivors, how to manage those cases effectively, and so on. And that course is accredited by the Law Society of Ontario for those very precious continuing professional development hours that lawyers are always looking for. I know Saskatchewan has a similar course that's delivered in person. I don't know the details about it, but I'm sure other provinces have other projects that attempt to get training into place for lawyers, because I'll be honest with you, there's not a lot about this at law school. So there's lots to fix, but there are also a lot of fixes in the works. There's a long way to go before family court will be a safe place that provides appropriate outcomes for survivors of family violence and their children. But I really do believe that we're slowly moving in the right direction. And I'm hoping that Linda's comments will similarly leave you with a bit of a hopeful feeling.
Thanks, Pam. I think I certainly felt some hope as you were presenting. And I'm going to try, as you said, just to also share some of the encouraging things that we see happening. And I want to talk in particular about trauma-informed approaches. I am now in control of my slide changer. So trauma-informed approaches, certainly people are hearing more about it, and we know that it's providing not just for a justice system or a court, but for many systems, it's an approach that is providing some hope. Basically, it's policies and practices that recognize the connections between violence, trauma, negative health outcomes, and behaviors. And the goal of being trauma-informed, using a trauma-informed approach, is definitely to increase safety. And I think that, again, going back to some of what Pam just said, increasing safety in terms of appearing in court and that whole process is definitely something that we want to do. When we talk about trauma-informed approaches, there are key assumptions that SAMHSA shares with us. And first of all, it's just the realization that there's a lot of trauma out there, and that it's important to be able to recognize signs and symptoms of trauma, and that our responses should integrate knowledge about trauma, no matter what we're doing, no matter what the work is that we're doing. And that if we do these things, that we can work to resist re-traumatization. I think what we see at this point in terms of Canada are pockets of trauma-informed organizations. So we see schools moving beyond trauma-informed programs like Mind Up and looking at how can the whole school be trauma-informed. Shelters are doing amazing work to be trauma-informed. And I think that we see hospitals also, again, many hospitals had programs for trauma-specific programs for someone who's looking for an intervention, but not being trauma-informed from the moment you walk through the door, no matter what floor or what service you are looking to receive. And that's a tall order for sure. We see some really exciting work in terms of sports leagues, Boys and Girls Club in terms of trauma-informed sport, children's mental health centers, again, moving beyond a program or a specific intervention that addresses trauma. Not that those aren't still very important, but actually, how can the whole organization respond in a more trauma way? And we're beginning to see some work being done in youth detention centers, correctional settings, in police departments, just beginning, and some rather hopeful work in terms of some courts. So the goals of trauma-informed courts, if we can use that expression, it's really to minimize harm. What's important is that the goal is not to treat trauma. So we still need services and programs that are there to treat trauma. But this is more about minimizing perceived threats and to avoid re-traumatization. The very things that in terms of the problems that Pam identified and some of the experiences of survivors that I described, don't do that. So to fully engage families is another goal, and that's critical because it's based on the assumption that engaged parties will lead to better outcomes in terms of the matters before the court. So when people are fully engaged, what we know is that they're most likely to be fully engaged if we enhance their safety and we promote their agency, the control that they have. So one of the other things that's really critical to a trauma-informed approach is adopting a universal precautions approach. So that means that given how pervasive trauma is, this approach says we should respond to everyone coming to court as if they've been affected by a traumatic event sometime during their life. So a universal precautions approach reduces harm and provides positive support for people coming to court by embedding trauma-informed approaches into all aspects of policy and practice. And we'll look a little more closely at what that might mean. So some of the early work in this area has been led by the National Council of Juvenile and Family Court Judges in the US, And they've partnered with leading trauma experts and also members from local courts. And they've actually looked at courts and they've developed an audit or a consultation that helps courts start. So it creates a baseline, and they complete the audit by talking with a range of stakeholders, holding focus groups, having surveys completed, and actually making observations of court hearings. And there's a number of areas that audits look at, or trauma consultations, both language is used. But first of all is, what's the understanding of trauma? Does the entire team in the court and other professional stakeholders demonstrate an understanding of how trauma, past or present, may affect current actions of parents and youth involved in the system? Another area is engaging consumers. Are parties engaged in the process? And we just talked about the importance of engagement. How are they treated in court? Are they treated with respect? Are their strengths recognized? Another area is identification of trauma. And some of the work that's been done is looking at a screening protocol being in place. And that screening protocol, part of what they look at is flagging trauma, and then looking to see if knowledge of trauma and identification of trauma is actually being part of decision making. So is it informing decision making? And then knowledge of resources, of course, what's available in the community, what and where can you find trauma-informed services and evidence-based programs for specific trauma treatment? Are families being referred? Are there barriers? And if so, what kind of barriers are getting in the way of families being able to access those resources? And also an area that we might not think of, but secondary traumatic stress. And is there an understanding by all stakeholder agencies, the child protection services, lawyers, the court team, of the emotional toll that hearing about violence and trauma may take on staff? And are there resources available to professionals to cope with this stress? So some of the work that's been done also has identified promising components of being a trauma-informed court. The first piece is engaging the whole court team. It's not okay for just judges or just lawyers. The entire team and the stakeholders, the custody evaluators, child protection services. So we need the whole team to be involved. And like almost every other change that happens, then there's a need for a leader within. And there's been some wonderful examples of leaders from within in the 11 pilot sites that have been studied. Most often it's a judge that's the leader from within, but not always. Other promising components are trauma education and training. And this is a critical component, and it can't just be one-off. It's got to be ongoing and looking at different dimensions. We talked about some of the environmental factors that can really support people who are dealing with trauma, and especially traumatic brain injury. And so the courts that are trauma informed are taking a look at their environment. And you know, the picture here, it doesn't mean that you have to paint your walls pink, but they are looking at lighting. They're looking at noises that may be happening in terms of doors banging. They're looking at signage in terms of clear signage, and also their communication style in terms of being clear and repeating messages. That would be helpful. Other components include somehow communicating the vision to all stakeholders. And they've seen that that has really made a difference in the progress that also needs to be monitored and evaluated. And that's usually done by a team. So far, in terms of the work that's been happening, in terms of court team members, as well as people with expertise in trauma from outside of the court, and also people in terms of that their specialty is more about evaluation. So that progress creates the feedback loop in terms of the monitoring and evaluation, which really helps people to move forward. So there's just the beginning, I would say. Perhaps some of the advances that have been made have been most clearly demonstrated in terms of specialized courts or treatment courts, but also we see it moving beyond those courts. And some of the things that when they look and talk about what's been accomplished, they share some things that might be more readily done in terms of first steps. And that first is creating a shared understanding of trauma and what it means to be trauma informed. And that ties in again with training, but also engagement and the buy-in. Prioritizing secondary traumatic stress has been seen to be really important. Promoting safety through positive interactions. So what's the language, the tone like in terms of courts? Is there, when there's anger expressed by a client, is there an attempt to understand what might be contributing to that anger rather than just trying to shut it down or to assume that it's not coming from a reason such as trauma or experiencing violence. Also in terms of seeing a client that is struggling with forgetfulness, having a difficulty seemingly tracking what's going on and trying to tell their story, make their case, then I think that, again, having an understanding and having some compassion and consideration from where that may be coming from is also very, very helpful. And something that isn't always available, but to provide separate waiting areas so that survivors aren't exposed beyond what is absolutely necessary to the person that has created harm. So again, it's a start. It's a little bit of hope on the horizon to add to some of the really, I think, exciting things that are happening in Canada that Pam outlined.
Thank you very much, Pam and Linda. I'm sure you wish you had 3 hours each for all the issues, and
Always.
but you're probably going to need 3 hours each for the questions. Some excellent questions have been posted, and I'm going to start with the easy ones, and I'll work up to the hard ones. So, Pam, I think people in other provinces are jealous of Luke's Place, and I wonder if you know if there's similar places like Luke's Place in other provinces.
As far as I know, there's nothing exactly like Luke's Place, and we do feel very fortunate to be able to operate in Ontario as we do. We're happy to share with people who are interested in starting something similar or building on something that already exists, so that it has more options that it can offer to women. But Luke's Place really, I can say this because I wasn't part of its creation, so I can say it without sounding arrogant. Luke's Place really is rooted in its community. Unfortunately, the beginnings of the organization rest in the homicide of a young boy by his father during an unsupervised access visit. But the community really came together after that homicide and said, we want to do something so this doesn't happen again. And from that came Luke's Place, and it's grown steadily in terms of its reach. And I think the systemic work that we do now is sort of the newest part of what we're able to offer women. So we're happy to talk to others who are interested in picking our brains.
Pam, and start with you, Pam, and maybe Linda has comments. There seems to be a number of questions that touch on the issue of what is violence and abuse, because obviously the average person, maybe including judges and lawyers, sees domestic violence, gender-based violence as really being physical in nature and may not recognize psychological and emotional abuse and coercive control. Any comments on the extent to which the Divorce Act and various provincial legislation are trying to define that as well, and how that word gets out?
Well, I'll just make a couple of comments about the law, but I think it's important to hear from Linda because the law is just a really small part of how we look at these issues, and often not a particularly helpful part. I think it's really important that the Divorce Act and then some provincial legislation is now providing a definition of family violence that includes explicit reference to forms of abuse that are not physical, because you're absolutely right, Peter, that is what women have the most difficulty having taken seriously in the courts. A woman who can come in with a long track record of assault charges laid against her partner or hospital visits with serious injuries is in a better position than a woman who is detailing a history of psychological and emotional abuse. I've certainly had clients, many over the years, and I'm sure Linda has too, who have said to me, I almost wish he had been physical with me because it would have been easier for people to believe that what was happening was abusive. So certainly the changes in the law are an important first step, but without proper education for all of the people who are going to be interpreting and relying on that legislation, and that includes some of the folks that Linda talked about when she was talking about a trauma-informed court, assessors, clerks, lawyers, mediators, and judges. Without education for those people, the changes in the law are going to remain words on a piece of paper. And I don't think that we're going to see them result very quickly in better outcomes. So the education has to be considered as important as the changes in the law. So Linda, over to you.
Okay, well, I will just add, Pam, that certainly the emotional aspects, and emotional safety, the abuse that impacts that, I think, is often harder to demonstrate. But we know that in addition to emotional abuse, financial abuse, spiritual, most of us are familiar with the power and control wheels. There's so many aspects to coercive control that are difficult to demonstrate. But I wanted to just add another element that I think is often missed. And that is that what a survivor may feel is salient often isn't what is perceived to be salient to courts. So we often hear or think, I think from outside, we may look at that the physical violence has to be the most horrible thing. It leads to injuries, it's visible. And I think often what's salient are the ongoing demeaning degradation that happens towards a partner, the things that are done to harm her emotionally, psychologically in front of her children, and her worries about children. Yeah. So I think those kinds of dimensions of intimate partner violence are so important and so salient to women, but aren't often what the outside world, especially in terms of court systems, focus on.
I couldn't agree more.
Yeah. One of the questions is about disclosing the violence. So the assumption is now that it's in law, the Divorce Act, and as you said, Pam, different provinces and territories are going to amend provincial territorial legislation to align, hopefully. When someone discloses violence, the concern expressed is what happens with those, if that disclosure falls on deaf ears, is it going to make it worse? So I guess the question, it's really two parts. One is there a harm in disclosing violence if you don't have an informed lawyer or judge? And I guess part B is, how do we have lawyers and judges who are informed? Because we're changing the law, but we're not changing people.
Well, you've now asked the question that does require 3 hours to answer. And I think it's a really important question. I've spent many years talking about how it's important to encourage women to disclose abuse, and that this is evidence that we need to get into the family court case. And I still believe that. But unfortunately, there's a good body of case law in Canada and in the United States that indicates that once a woman raises that issue, she's potentially subject to all kinds of backlash. The abuser will, of course, deny it or minimize it, or make it sound as though, you know, it happened once or twice, but really it was in response to this, that, and the other thing that she did. And worst of all, he may level an allegation of parental alienation against her. And those, you know, we don't possibly have time to talk about that this afternoon, but once an allegation of parental alienation has entered the courtroom, it's like nothing else exists anymore. And the court is entirely focused on that allegation. So I'm not going to answer the question yes or no, should a woman tell her story of abuse in her family court case, because I want to believe that she should, despite the fact that it often creates further difficulties for her. And there's great research in Canada by Linda Nielsen and in the United States by Joan Meyer that I would refer people to if they want to know more about that. We have to educate the players in the system so that they understand what abuse looks like and that it isn't just physical. Linda?
I was just going to add, Pam, that we actually hear from some survivors that they're legally advised not to raise the issue of domestic violence.
Pamela, there's a question about mediation, and obviously the Divorce Act and also provincial and territorial legislation encourages referral to mediation. Where we are at today in terms of appropriate screening for violence?
Well, generally, mediators are way ahead of lawyers in terms of their professional associations that either require or strongly encourage, and have developed very good screening tools. So as a lawyer, I'm hardly going to point the finger at mediators in terms of screening. I think what's most important for survivors of family violence is that they be made aware of the span of options that are available for dealing with their case. Mediation is one, litigation is another. Many provinces now have collaborative law, that's another. I don't think any one of those should be positioned as more attractive than the other. And yet much legislation, including the new Divorce Act, says that lawyers should encourage mediation. I don't think that's reasonable. I've worked with women who have left highly abusive relationships, have been through mediation and have found it fantastic because they had a really good mediator. Because they were quite strong themselves, you know, well on their healing journey, and they had good psychological and emotional support on the side. And in fact, some women have said, you know, he's more likely to follow the outcome because he feels like the abuser, because he feels like he crafted it. He never would have followed it if it was what a judge had told him that he had to do. So I'm never going to say that mediation should never be used in cases of family violence. What I object to is it being favored as something that everybody should consider first, because it simply is not always an option. And we have to remember that litigation can be pretty darn abusive too. You know, I talked a bit about some common legal bullying tactics. That can be very difficult for a woman to manage emotionally, especially when she's dealing with the trauma that Linda described earlier. So neither one is really that great until the people in the system understand family violence properly.
Pam, thoughts about risk assessment and screening? I know you've written about this, and I know we have Jackie Campbell, who developed the danger assessment scale. I know she's
well, I can really only talk about screening. I'm not a risk assessment expert or even novice. I think one thing I would say is that we have to understand that they're very distinct things. They're not the same thing. And I think that screening is critical. I think that every lawyer with a new family law client should be screening. And I'm hoping that the Department of Justice tool will be helpful in supporting lawyers to do that.
Should that be a standard of practice? Like,
yes.
I think like in Ontario, the police are the only profession required by law that if they have domestic violence call, they have to do a risk assessment. Do you think lawyers should have to do risk assessment as part of their standard?
I think they should have to do screening. And through the screening, they might identify that a risk assessment is necessary. I don't think lawyers should be doing risk assessments. For one thing, they've got enough to do already, but it's not their expertise. But the screening, yes, and then from there, a determination about whether a risk assessment is needed.
Now, there's questions that we've received about how do you get those experts into court. So if there are specialists, if the lawyer does screening, then clearly somebody else is going to have to do the assessment, and that has to be properly put before the family court judge. So what are your thoughts about how people reach out to experts or have someone do an appropriate assessment?
I think we should be seeing a lot more experts in family courts, and I'd love to hear Linda's thoughts about that. The challenge is that when you've got more than half the folks in family court there without lawyers, they don't know that that's an option. They probably don't have the resources to pay for an expert. And so we're missing an opportunity to have the court fully informed by somebody who's got that expertise. Linda, what are your thoughts?
I would agree in terms of the barrier, or one of the barriers is the resource issue in terms of, for many people. I wanted just to add to when you were commenting about screening, I would just like to say in terms of some of the screening that's done, I think the screening, as you mentioned, Pam, for domestic violence is critical. I'd like to add, should we also be considering screening for trauma? Mm-hmm. And you look at some of the screening tools and some of what we're learning about trauma, and you think that they're finding some of the systemic reviews are finding, reviews are finding that even the very brief trauma inventories, some have 4 items, some have 10 items, are really as effective as some of the more complex screening tools, like you said about the domestic violence. It's not assessment. It's not assessment for trauma, but it can be an important flag.
I agree.
Another question that's come up a couple times is the importance of having a cultural lens, looking at families in the family court and understanding the context of their lives and their families' lives. Any reflections about the extent to which the courts are both trauma informed, but also need to be culturally informed in terms of looking at the context of the families they're seeing?
Linda, you've done a lot of work in that area.
I would start us off, and I would say that in terms of a true trauma, we often say trauma and violence informed approach. And the reason we say that is because you can't really be trauma informed and not be looking at the context that somebody is living in the same way that we talk about the trauma and the experience of violence being shaped by somebody's social location and the kinds of associated oppressions with that location. It becomes really, really important. So we would actually argue that trauma and violence informed or trauma informed, that's actually a part of it. And that perhaps didn't come out strongly enough in terms of the slides in the discussion today, but it's a very important piece. I'm glad that somebody raised that.
Okay. Seems to be a lot of questions that come back to education of lawyers and judges and court-related personnel, and also shortage of resources, depending on where you are in Canada, whether you're in an urban or rural center, getting access to resources. any comments, Pam, on in your travels either across Ontario or across Canada about seeing any creative solutions when in terms of limited resources?
One of the biggest challenges that I hear about wherever I go or whoever I talk to is this issue of having access to legal representation, or at least some legal advice. And there's no doubt that's a bigger challenge for women in small communities and in rural and remote parts of the country. There may be one family law lawyer in the community, and if the abuser's already seen that lawyer, that means the woman's got no one she can access, or there may be none. I've worked in communities where women have to travel 2 hours, and that's assuming they have a car, to get to a city that's big enough to have any family law lawyers at all. And I don't really want to sound like I'm continuing to toot the Luke's Place horn, but we've developed a virtual legal clinic that certainly doesn't give women legal representation, but it does mean that wherever they are in Ontario, they can electronically have a consultation or several if they need it at no charge, no cost to them, with a lawyer. We have a team of lawyers in various parts of the province who have been through our training for lawyers. So we're satisfied that they have a basic understanding of the dynamics of family violence. And women can talk to those lawyers. I think that's a model that is one that could be adapted and used in other parts of the country. And it would be a small step towards increasing access to lawyers for women wherever they are. I mean, we've got this technology, we've all been living on it for the last 9 months. Let's use it not just for our own purposes in conducting our work, but to connect very vulnerable people with the lawyers they so desperately need to talk to.
This might be a question for Linda and maybe Pam, you have reflections as well. That's the issue of addressing violence in terms of what it means for parenting. Obviously, we're talking about intimate partner violence or domestic violence, gender-based violence. We're often talking about a victim and an abuser. And the question is, what are the implications for parenting? And is there remediation possible? Are there programs available to deal with parenting victims that are impacted by the violence, and also the parenting of abusers? Obviously, court makes time-limited decisions about supervised contact, but are there thoughts about what kind of intervention should be taking place?
Well, first of all, I think the impact on parenting is something that's really important. And for a long time, we looked at impact in terms of on individuals. What was the impact on a woman? What's the impact on children? And we talked a lot about impacts of children in the literature over the recent past. But what has received less attention is exactly the impact on relationships within the family, such as the parent-child relationship and how that impacts parenting as well as the relationship, and how it affects siblings. And I think that we're seeing more and more that community-based programs are looking for ways to make sure that interventions for children also include interventions for mothers, at least a component, and that also we're seeing more specific interventions, not available as widely as we would like, but interventions that have strong evidence to support that when both mothers and children, when the trauma is looked at, then that becomes really important, because sometimes trauma may be dealt with in terms of a child, sometimes a mother, but in terms of the impact on that parenting and the mother-child relationship, often that piece is missed in terms of that important context. So I think that parenting is important. The unfortunate part is that often, again, there's a cross-sectional snapshot, and what's seen is parenting as opposed to the impacts on parenting of the abuse. And so instead of looking at how is domestic violence impacting parenting and this parent-child relationship, then the focus becomes, I'm not sure about this person's parenting. And so we know that the potential as a parent can be compromised But we know that there's also support and healing that will occur, and that's not a reason to make decisions that shouldn't be informing decisions in terms of shared parenting. So I'll stop there for a minute and pass it over to you, Pam.
You know, this is not exactly the same thing, but definitely related to what you're saying, Linda. And it drives me absolutely crazy when you're looking at affidavits and documents in a custody and access case where there's a history of abuse, and mom's been the primary caregiver prior to separation and quite likely in the immediate aftermath of separation. And the abusive spouse or partner has never apparently had any concerns about her parenting during all of that time. But now suddenly in the family law case, he's raising all of these allegations about her inadequate parenting over time. And judges never seem to stop and look at him and say, well, how come you never said anything about this before? But they sure like to stop and look at the woman and say, you're raising issues of abuse now. How come you never raised them before? There's such a gendered inconsistency in how the courts look at evidence put forward by women compared to evidence put forward by men as it relates to parenting.
Pam, just one last question, which is an easy one, but it's confusing for the non-lawyers. So obviously, part of our working together across the country now to try to develop communities of practice is trying to get mental health professionals more informed about the law, family law, and also have family lawyers and judges more informed about trauma-informed approaches. I think a confusing thing is the Divorce Act itself.
Yeah.
So a number of questions are, Divorce Act only deals with people who are legally married or deals with people who are also in common law relationships? So.
No, you have to be legally married in order to be able to use the Divorce Act. Not only that, you have to be applying for a divorce. So let's say that I'm married to my partner and we separate, but we don't have the extra money to pay for a divorce right now. We can't use the Divorce Act to sort out all of the other issues we have to resolve. We have to use the provincial law wherever we live. If I'm not married to the parent or the other parent of my children, or maybe we've never even lived together, or we've lived together for 30 years, we still cannot use the Divorce Act because we're not married, and therefore we're not seeking a divorce. And so, you know, we can have a whole other workshop on what it means to be legally married. I'm not going to get into this now that we're just a couple minutes till the end of our time, but you have to be married according to the laws of Canada before you can use the Divorce Act.
And if you're not legally married, then you're dependent on provincial laws. So for example, in Ontario, as you mentioned, the Children's Law Reform Act is being amended to be consistent with some of the wording of the Divorce Act, and hopefully other provinces are moving in the same direction.
And some are ahead. The Family Law Act in British Columbia for several years has used that language. In fact, I think it was probably the model for the changes to the Divorce Act. So there are provinces who have already implemented legislation that is more directed to the issue of family violence, and others that are in the process of doing so now.
Okay. And before I thank both of you, do you have any last minute reflections, sort of just reflecting on all the questions? There's a torrent of questions and comments. We'll try to capture what we have in the questions in chat, and we'll be spending more time reviewing that and hopefully getting answers to people. Pam, any last reflections?
I was really happy to be able to be part of this discussion. We need more of them, and hopefully through this project we can have more of them. It's really important to have people from all these different sectors thinking and talking about this issue together.
Okay. Linda, any last reflections, seeing all the questions and comments?
I think just to say that it's a good exercise to force ourselves to spend some time thinking about what are some of the hopeful signs and what are some of the progress that is being made. It's as you know, we've talked about, it's a long ways to go, and there just may be glimmers of hope on the horizon. But I do think that's worthwhile, and that it's something for us to be mindful of.
Okay. Well, I want to thank you both very much for your time today and your very helpful presentations, very stimulating looking at all the comments. And there's still, I apologize, some people are writing about questions that we didn't get to, but hopefully we can get Linda and Pam back and we can dive in deeper with some of the questions and answers. There is, in the chat function, there is a link to our evaluation for the session. And also if you complete that, you can get a certificate for attendance. There is no exam today or quiz, but you'll get a certificate for attendance. So thank you all who are online, and we look forward to the next occasion to be able to have a function like this. Thank you, Linda and Pam. Bye for now.
Thank you. Bye, everybody.